To just say we're going to eradicate any kind of ideology, I think is an ideology. Like the very fact that they're taking that position is their ideology.
Welcome to the TroopHR Podcast. I'm your host, Taylor Bradley. Today we sit down with Julie Werner. She's an experienced employment lawyer and partner at Lowenstein Sandler. Together, we're going to unpack what may be in store for us in 2025 in the employment law landscape. In particular, we'll explore how the new reality of a second Trump administration may impact HR leaders, both through executive orders, a conservative Supreme Court, and a conservative legislature. But before we get into 2025, we first asked Julie, in her experience in 2024, what stood out to her on the employment law landscape?
From an employment law standpoint, I think the biggest issue, or one of the biggest issues in 2024, was the Federal Trade Commission, the FTC, had proposed a rule that if it had become effective, would have banned non-compete nationally, subject to extremely limited exceptions. And so that caused a lot of angst for a lot of our corporate clients who rely heavily on non-competes in the right circumstances to protect their interests. And it was really until the very last minute, as much suspense as a lawyer can have in some of these situations. I realize this is all, watching paint dry to some other people, but in legal speak, right, waiting to see whether the non-compete rule was going to become effective, whether the court was going to enter an injunction preventing it, which is ultimately what ends up happening. Several courts actually ruled, including one court that ultimately issued a national injunction, a ban on the rule becoming effective. So that is now up on appeal, and sort of segueing into 2025, with the new political administration, it seems pretty unlikely that the FTC now, once it becomes a Trump administration, it seems pretty likely that they will abandon the appeal and that the rule will die on the vine pretty definitively. But that was probably, I would say, the biggest issue for 2024 for employment law geeks, was whether or not that non-compete ban was going to become effective.
I was at a summit earlier this year where we were able to speak to Lina Khan, the current FTC commissioner.
Yeah.
And she had some quite ambitious goals for the FTC heading into at that point, was supposed to be the second Biden term. Are there any other rulings or precedent changes that we're expecting now in the Trump administration?
So it is interesting, as you mentioned, Lina Khan, and a lot of people were waiting to see what was going to happen to her, because it actually, interestingly, Matt Gaetz came out with a brief he had filed fully in support of Lina Khan and the FTC rule, but we see what happened to Matt Gaetz now. And I think J.D. Vance actually had said some things potentially supportive. So that clearly, I think has taken a turn, and I'm sure she'll land somewhere nicely and probably be a very effective lawyer or professor or whatnot, and probably more to come from her in the future. She, is pretty young and very successful in what she was able to do during the Biden administration, notwithstanding this specific issue. In terms of 2025, I do think what's been getting a lot of press, particularly, is this pendulum swing on DEI. And both from a legal standpoint, there increasingly have been cases where employees, job applicants, people have challenged where they feel that they feel that they were treated unfairly, in the sense of oftentimes what's referred to as a reverse discrimination. And in fact, a case that's pending before the U.S. Supreme Court that is to be decided, is to be heard. I think oral argument is to be heard in late February. Probably it'll be decided by the end of the term, typically at the end of June, is what is the legal standard for a reverse discrimination claim. So that is a key case that will be, before the Supreme Court. In addition, there have just been cases that have been pending throughout the country where employees or job applicants feel that they were mistreated. Essentially, often, not always, but often white men who are saying they were mistreated in favor of somebody else who was of a different race or a different gender, or that they were encouraged to make certain decisions with respect to hiring people, and that they were penalized because they didn't follow what they had been told they were supposed to do. And so that's an area where there is increasingly case law. There you see in the business side, just businesses looking at it from sort of a cultural or sort of, you say, I guess even stepping back, right? So in 2020, after George Floyd was killed, there was a host of business activity where it almost felt like each company, one more than the next, was trying to say, oh, we're doing this. And another one said, well, I'm doing more than this. And it was, everybody sort of was going on that bandwagon. I'm a bit of a cynic, as you can hear. And some of them were very meaningful and earnest and I think genuine. And some of them I think were a little bit of, I guess jazz hands and trying to optically look like they were doing things. But you see significantly, I'd say in the past 6 to 8 months, a significant shift in that regard. It appears increasingly that a lot of companies, because of threats, active shareholders or just active, activists challenging businesses in terms of in the boardroom, the business decisions being made by a lot of companies. And so there's a whole host of companies that have said that they are scaling back their DEI initiatives. And so I think that's another big area for 2025, where, like I said, in terms of the case law, in terms of the business activity, there is also a bill that is pending in Congress, and we'll see whether that gets any traction to dismantle DEI. That's the name of the bill. I think it's called the Dismantle DEI. Again, the name is probably half the sensationalism of it, but I do think that that is a big area where we will see a lot of activity this coming year.
So let's talk about that a little bit. First off, one of the concepts that I've been discussing over the past 2 years is something called HR drift, where I do feel maybe even well-intended HR is overcorrected in some areas. And a classic example that I gave is a team that I'm aware of removed a vice president of infrastructure engineering from an executive talking panel for an all hands of the company, specifically in Slack. They were talking back and forth because he was a white male. And I understand what they were trying to achieve, but it's those types of things that I do think are going to end up in a court. And it sounds like there are cases that are making their way through the system where maybe well-intended diversity initiatives are leading to legal hot water for some corporations. Are you seeing more of those types of cases come forward, or are they still novel cases at this point?
Well, I think this just to step back and what I believe really always has been the case is we know under Title VII of the Civil Rights Act that we are not to discriminate based on various characteristics, including race. And therefore, if we're not to discriminate based on race or gender or other various protected characteristics, really what that means is we should not be making decisions white, black, purple, green, orange based on race. And so I do think, again, what I don't know, your phrase was HR drift. I mean, there's this shift, I guess, is kind of what you're saying. Yeah, I don't think it would be correct to exclude somebody, regardless of their race. So I don't know the specific situation that you're referring
Sure.
to, but if somebody were excluded, a white man, simply because of his race or his gender, that seems to me improper. And, again, there's more to be having a claim than just being excluded from a chat or
Right.
whatnot, right? I mean, there has to be some type of adverse action. And I don't know, being excluded from a chat alone would rise to that legal standard. But certainly optically, if people are making decisions on bases like that, that seems problematic to me. And I do think, again, in this, call it HR drift or shift or whatnot, I do think people are increasingly sensitive to those types of issues.
So on a small group I was able to attend at the CNBC CEO Summit in July of last year, you had Mike Johnson present, as well as some senior echelon from the GOP House Majority. And they made it clear in no uncertain terms that they did not view the responsibility of companies to be advocating for what they view as ideological opinions. And if they remained in the House majority, as well as if they picked up the presidency, because again, this was in July of last year, they were going to pursue legislative objectives. It sounds like there's one bill that you had mentioned, but what other types of mechanisms should HR leaders be looking out for of legal implications of the type of DEI work?
I mean, look, on the other hand, there is a valid basis historically, and courts have recognized, certainly in the educational space and in other areas for affirmative action.
Hmm.
Now, the affirmative action area, took a shift in July, or I guess it's late June of 23, when the US Supreme Court invalidated the affirmative action plans that Harvard and the University of North Carolina had been using. And so, but I think inherent in that is a recognition that, and that is what affirmative action has always been intended to do, is that historically, to the extent that there have been disproportionately impacted groups, and there have been a variety of cases, especially more so in the public sector, where police departments and fire departments and other areas, more of the case law historically, especially before the U.S. Supreme Court, and affirmative action has been, it seems to be more in the public realm. And when I say public, I mean, again, firefighters and police departments and things of that nature, not public companies per se. So, but I do think everybody recognizes that there has been this historical, that there has been a valid basis. I think the question is, at what point, if any, have the wrongs been rectified, and or is there a continuing obligation? And there is a legal burden for a company to use affirmative action, and inherent in that. And that is part of the issue that is pending now before the Supreme Court, this case about reverse discrimination. There have been cases that say where the majority of the workforce historically has been, typically, let's say, white male,
Mhm.
that companies, in an effort to remedy those past, that past representation, has the legal right to change it. So there is already established law historically to that point. I think the question is more of a reckoning, like, are we at that point or not? Right. So, and I don't know, I'm not the person necessarily to be able to answer that. But from a political standpoint, and again, I don't profess to speak for any one politician or candidly understand what their perspective is, but to just say we're going to eradicate any kind of ideology, I think is an ideology. Like,
Yeah.
the very fact that they're taking that position is their ideology, right or wrong. To say that there's no ideology doesn't really seem accurate.
Yeah, from the audible gasp in the room when the GOP representatives shared that, and this was a room filled with Fortune 100 CEOs, so this is a pretty staunch crowd, and I think it either way, legislation or not, had an intended chilling effect, especially with the outcome of the recent election. These cases that you're referring to on the reverse discrimination, it does seem that it's just tying back to existing precedent is discrimination on the basis of sex or something that's already been well established, I guess, in stare decisis, right?
So yes and no. Again, the legal standard has varied by federal circuit. So our appellate courts across the country at the federal level, there are various what they call circuit courts, and different circuit courts have established different standards about what is the standard for. In other words, if you are historically in the majority, which typically a white male would be considered historically to have been the white majority for a particular business, um, it is a different legal standard depending on whether you are in Ohio or you're in California, for example. And because there is a split in the circuits, that is typically when the Supreme Court is more interested in taking a case, when there is a split. So when you say precedent or stare decisis, there is different precedent in different circuits. And that's why typically a case, the Supreme Court is interested in taking a case when there's a split. So it will give an opportunity for the Supreme Court to weigh in at a national level what should be the standard for a plaintiff to be able to prove reverse discrimination. And I think recognizing the composite of this court, I think many can likely predict that they will likely be sympathetic to a plaintiff, a white male, for example, who is alleging that they have been discriminated based on their race and or gender. You know, we don't know exactly, obviously, how the court predict what the court will do, but I think recognizing the composite of this court, I think most people recognize that the court will be more sympathetic to somebody in that situation. And therefore, if the court does rule in favor of this person, ultimately it will have a national impact, to your point. And likely that's something we would know by the end of the term, which would be the end of June.
And to many of our listeners, I'm sure they recognize that the Supreme Court of the United States, the makeup of it, historically, or at least for the past while, has been liberal leaning. And it has now switched to a more conservative. So when Julie is reiterating that the new composition of the court may have an impact, it's a lot of changes have come through, or precedent has been overturned by the new composition of the Supreme Court. One other case that I'm curious if it does have a connection into all the regulations that our organizations face was the precedent change of the Chevron doctrine. My understanding is this changes the way that certain agencies can regulate. Will that have an impact on us as people leaders?
So historically, agencies, administrative agencies, which are part of the executive branch, right? So typically, Congress is our legislative branch that passes laws. And the administrative agencies that fall under the executive branch are typically more specialized areas. So, for example, the Department of Education or Energy or Labor or whatnot. And so each of those agencies will issue regulations that correspond essentially to a law that was passed, that the legislation, that was passed by the Congress and signed into law by the president. And so what happened was, typically, because those agencies were viewed to be experts in their various areas, they were afforded more deference in terms of how they interpret the law, their regulations, and to really have the breadth and scope of how far they're willing to go. And where people have pushed back or challenged is to say, firstly, there's so many and they're very lengthy and long and nobody could possibly understand them and they're very complex, but also just that the level of intrusion, I guess, how far they can go in imposing their will. And so while historically they had a lot of deference in terms of how they could interpret the law and how far they could regulate, the case that you're referencing that came out last year basically overruled that and said, we're not going to give deference to these agencies, basically, in terms of interpreting their laws and how far they can go in implementing these regulations. So that is interesting, obviously, in terms of that case that came out last spring. Now you have in a new political administration and you have Elon Musk and whatever this Doge thing is or whatever, right? Where they've said we want to cut red tape and we want to cut regulation and we want to cut government spending. That is an area, and how much of that plays out in practice, it's hard to say. But for HR professionals in the Department of Labor, typically is where we see a lot of these things. Or even, for example, when you think about the EOC comes out with this rule, you have to file this thing by this day, and you have to list the number of employees and all these various statistics, right? I mean, those are cumbersome things that on the one hand, you might say are well-meaning, and gathering that information perhaps leads to, making sure that there's a sense of equal opportunity or fairness or things that's where that's supposed to be the mission of that organization. On the other hand, one may say, well, who gave them the right to say I have to create all these EO1 forms and all these other charts and things and file all this data that seems very cumbersome, and to what end? So you could see things like that potentially being rolled back, which I do think most HR professionals probably would be pleased about, probably would prefer it. Again, not to say that they certainly they support, as most of us do, equal opportunity for people. But the question is whether or not all this so-called, paperwork of sorts, how does that further the mission? And so then there's going to be less deference for those kinds of rules, which may be helpful, and HR professionals may presumably be happy about that fact. Likewise, even the Department of Labor had also the last year increased the salary threshold for employees to be considered exempt under the Fair Labor Standards Act. And ultimately, right, so the salary increased last July, and then it was supposed to increase again this coming January. And then in December, a Texas court issued again a national injunction saying that the Department of Labor had overreached in increasing the salary threshold in July, and that the new salary increase for January also didn't have to go into effect. Now, mind you, these dollar amounts are pretty low to begin with. And so, that is the issue when you have a national standard. And I do think one of the other things that HR professionals should expect is The states and cities are obviously going to step in areas. So even if there's a rollback at the federal level, even on things, I mean, candidly, to be able to say that $36,000 is so cumbersome, and I guess it depends where you are and the geography really varies. But if you're in a place like New York or California, for example, the salary threshold is already, pretty much close to double that in any event. So, even if HR professionals do see a rollback at the federal level, that's not going to end the story. I think candidly, you're going to just see a ramp up more so at the state and local level in response.
The other question that I have, and just a couple more as we now start to approach coming in for a landing, is Donald Trump or President elect Donald Trump is, I would charitably say, is spontaneous. And so, are there any executive orders that you're expecting or keeping an eye on that may switch or change on January 20th?
I personally can't say that I'm aware of anything that will have an immediate impact from an employment law standpoint, other than I'm not an immigration expert, but obviously there's been talk, including even in the past week, about HB1 visas and Elon Musk weighing in one way and others weighing in another way. I do think it increased generally, and I don't know that it's a January 20 thing, but the climate around immigration is also obviously a big issue for the country. And, companies that historically have been more lax in their hiring in terms of looking the other way or their I-9s, or sometimes companies will hire people as independent contractors for various reasons, including that you don't need to get an I-9 or confirm legal status of somebody who is a consultant. So where companies may have been more lax in the past on things like that, I do expect, not necessarily on day one, but it does, I think, seem that there will be a big shift this coming year. And so companies, on the one hand, it is a little bit interesting in terms of the inconsistency, right? We just said we're to expect less regulation, less strict measures on a bunch of areas. Yet on the flip side, on the immigration side, I think there is obviously the talk is going to be increased regulation, increased scrutiny, and therefore companies should be careful about their hiring practices, making sure they know who is on board, that whether or not people have documents that may have expired. And sometimes they don't always, you're supposed to, I guess, sort of calendar these things, right? Even if somebody is legally authorized to work here for a 2 or 3 or 5 year period, sometimes people don't always update those things through HR. And that may be an area where people want to go back and start just kind of looking a little more closely under the hood to be prepared, because that is an area where I expect in 2025, we're likely to see more on, HR professionals should be prepared for that.
Yeah. And I think one maybe reassuring part heading into the next 4 years is we've been through this before. And in the prior Trump administration, one thing that we did have is a lot of delays in processing, or certainly more scrutiny. It felt like every case that we had was getting a request for additional evidence. On a personal state, my wife, who was an immigrant, we expected her visa or her green card processing time to be, it was at the like a year or so at the time, but it was ended up being multiple years. So at a minimum, we should be expecting delays, and certainly be consulting with your immigration counsel proactively would probably be a good choice. Now, for the rest of 2025, is there anything that you would encourage HR executives or leaders listening to this podcast to maybe keep in mind that we haven't already discussed from an employment law standpoint?
Well, the other big area I think that companies continue to struggle with is this whole notion of return to work and remote work and finding the right balance. And so that is, I do think I was not surprised to see the increase in return to work efforts by a lot of companies, because I do think in terms of the job market, when it was more of an employee market, when companies were desperate to hire people earlier on, they were more accommodating. As companies increasingly were doing layoffs and they could be stricter in terms of their approach, it seems that the stricter approach then is to require people to be in the office. Obviously, there's pros and cons. There could be a whole separate discussion about the benefits of remote work versus, hybrid and full on, in the office work. But I do think that as we see hiring and layoffs and those sort of fluctuations, I do think has a correlation now with remote work and the likelihood and also just in general, now that we've had a couple more years of all of those sort of variables, seeing how that plays out in terms of the talent, loyalty of employees. I think a lot of, on the one hand, employees working remotely may feel appreciative, on the other hand, may feel less loyal to their employer because they feel less of a connection and those kinds of things. So I do think that is still an area where there is, even just in the past couple months, I guess Amazon was the biggest company we heard about, but certainly there were plenty of others. And I do think that is something that we'll be closely watching in 2025 as well.
Completely agree. And employment law aside, one thing that our listeners will have heard me say before is you got to remember high quality talent has options. So be mindful of that when you're putting ultimatums on the table or pushing for a certain aspect. I really do think people enjoy flexibility. And if you're able to provide that, but I also believe in a company's right to make decisions best for their business. So certainly keep that in mind. Final thing that I want to get into is I really enjoy when I get to meet a professional like you and just get some insight into the career that you've built. You've been at the same law firm for some time. What would be one thing that you learned along the way that you wish you would have knew on day one when you started with it?
Well, I can tell you I've been at my firm. It's funny you say that, for over 27 years. And it shocks me even just to use those words, because we have young lawyers who are starting with us who are probably not even 27 years old. So it really shocks me to be on this side of things. So again, what I think taking initiative, I would always tell people, and I think one of the things that has worked really well for me, even finding my way into employment law, is to take initiative, to see what you're interested in, to find the people in, and this is true for law, this is true for any area. I think it's to find the right people, to see what kind of work people are doing that you find interesting, to make the effort to reach out to them, to speak to them, to offer to be helpful to them, to take ownership of your career. I think people who sit back and just kind of let work come to them are not going to necessarily get the kind of work that they want or be satisfied with it. And so that's one of the things I think that has worked best for me. I guess the other piece of advice I wish I had known on day one was just to sort of relax a little more, to try to enjoy it a little more. But I do have to say, I've been very lucky. I really have enjoyed and continue to enjoy what I do, and work with some great people, really enjoy employment. Look, I mean, when you talk about issues about employment law, it's the human element of it, and and even including, the cultural issues that we talk about, I think is really interesting and makes it really fun for me and makes me happy to go to work every day.
And have you been focused on employment law this entire time?
I have. I have. I like a lot of law students, before I started at my firm, I did have a clerkship for a year. I worked for an appellate division judge in New Jersey. And one of the benefits I tell all young law students is when you clerk in the courts, each week you just handle whatever case is coming up before the court. And what that does is it gives you so much exposure to so many different kinds of cases. And candidly, it was almost by a process of elimination. I said, oh, that doesn't, this contract case doesn't sound very interesting. This criminal case, I don't see, I could do myself doing that. And a few employment cases came up, and I said, oh, that sounds really interesting. And I was attracted to it. And so, like I said, I kind of by a process of elimination found my way. And then I was very fortunate when I started at my firm that there were great mentors available to me who really kind of took me under their wing and taught me a lot. And so really grateful that I've had those experiences, and I try to, now impart that on other people as well. And it's been fun. I've been very happy.
I can clearly, and the listeners will too, you can hear the passion in your voice when you discuss not only the passion, but the expertise that comes along with it. And it's been thrilling to learn about. Final fun question for you here is, do you have a pet peeve or a thing in movies when lawyers are represented that they just get wrong, that you just want to set the record straight?
Well, it's funny you say that. I watched Suits like a lot of people last year, and the two things that stood out to me, it was like the lawsuit was filed in the morning, and by the afternoon they were like on trial or something like that. I thought that was interesting. And I do also think that law increasingly is a specialized area. There's so many different topics that, again, I'm an employment lawyer at my firm. We have over 350 lawyers and who are experts in so many different areas. You watch a TV show like Suits, the guy, I forgot his name, in the morning he's in court, in the afternoon he's doing a merger, and so I think the expectation that you're going to have a lawyer that is a jack of all trades, so to speak, I don't think is realistic these days either. I think really getting to a specialist, and there are so, obviously law is a very intricate area. And so getting to a specialist of whatever type, so those are the two things, I guess, in watching Suits. I thought it was a fun show. I just use that as a recent example. Those were the two things that stood out to me.
The two things that stood out to me as well. The other thing that I've always found interesting in law shows is how the lawyer in the courtroom will always walk up to the witness on the stand and speak to him. It's just like, usually you got to sit behind your desk. You can't go up and do that. So, Julie, if folks want to reach out to you, what's the best way to get connected with you?
Oh, that's great. Sure. My email address my name is Julie Werner, J Werner, WERNER at Lowenstein, LOWENSTEIN.com. Lowenstein Sandler, we're a firm with over 350 lawyers around the country. I sit primarily in New York and New Jersey, and we represent a lot of tech startups, hedge funds, life science companies. So typically company side startups through large size companies. Happy to talk if anybody would like to reach out.
Julie, thank you so much for your time today.
Thank you. Nice to talk to you.
Thank you for listening to this episode of the TroopHR Podcast. If you enjoyed this episode, we encourage you to subscribe and leave a 5-star rating. If you would like to learn more about our community, please visit TroopHR.com. In the meantime, keep living the dream.